Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. One of the things that happens when somebody goes to the Supreme Court with an application for interim relief, meaning you need to fix this problem while the case goes on down in the lower district courts, anytime that happens, most of the time, it's either granted or denied. And in 97% probably of these petitions for review, the court just does that. One word essentially response, denied or granted. It does not usually issue an opinion related to that. But today we have one of those which is consequential and where the actual opinion that grants the interim relief is essentially setting down some hard rules for the district courts to follow. And as somebody who works in appellate practice and who understands the role of the courts very well, this is a very welcome ruling on the part of the court. But you won't find it on the opinions page of the Supreme Court. You have to go to the emergency docket to find these opinions. And the opinions, while they are concurrences and they essentially state the court's reasoning, they're not basically a precedential opinion authored by the court, but they give a pretty good preview of where the court is going. Now let's talk a little bit about the thing that is at issue here. It's called a universal injunction. Those of you who were around during the first Trump administration know that he imposed a ban on people coming to the United States from certain countries in Africa and the Middle East. It was widely labeled a Muslim ban, but actually it did not have any reference to any religion in it. It essentially said if they come from these places and they are not vetted before they come, they can't come. And what happened? One judge in Hawaii, one single district court judge in the 50th state, issued a nationwide injunction against the president's executive order here. I'm sure the people who sought that relief were very happy about it, but there was a large group of people who were kind of unhappy about it because you got one judge in Hawaii saying no, that the ban can't be enforced anywhere because he said so. So the government did what it always does in that situation, took it up to the Ninth Circuit, and the Ninth Circuit, being the most liberal circuit in the country, essentially rubber stamped it, and it eventually wound up at the Supreme Court, where the Supreme Court overturned that nationwide ban without saying anything about whether the ban itself, being nationwide, was in some way appropriate. Well, as we'll see here in a moment, the judges have had it up to here with nationwide and statewide injunctions. And let's see if we can figure out why. Let's take a look at the opinion. This is Raoul Labrador, Attorney General of Idaho, versus Pam Poe by and through her parents and next friends, Penny and Peter Poe, et al., on application for stay. This was decided on April 15th. The application for stay presented to Justice Kagan and by her referred to the court is granted. The December 26, 2023 order of the United States District Court for the District of Idaho is stayed except as to the provision to the plaintiffs of the treatments they sought below, pending the disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of a petition for a writ of certiorari if such a writ is timely sought. So let me stop right there. So this is how the case got to the Supreme Court. In 2023, Idaho passed the Vulnerable Child Protection Act. Two children and their parents who were receiving puberty blockers challenged the ban in Idaho Federal District Court. Thereafter, the Idaho federal judge issued a sweeping injunction against not just puberty blockers, but against the entire act. It then went up to the Ninth U.S. Circuit Court of Appeals, which pretty much rubber-stamped the district court. The state of Idaho then filed an emergency application with the United States Supreme Court to get interim relief, essentially a stay of the district court's ruling. The district court issued an injunction, and the state of Idaho asked for it to be stayed except as it pertained to the two children who had the ban lifted for them for their puberty blockers. So at issue before the court is this universal injunction, which prohibited more than the plaintiffs had asked for. And the propriety of granting these universal injunctions has become an issue in this case. Essentially what they're saying is, until the case runs its full route and decisions of precedential nature are issued, the impact of the court's order is stayed, except as to the two petitioners here who have sought access to puberty-blocking drugs. Unfortunately for the state of Idaho, when the court issued its injunction, it enjoined the entire statute, not just that part related to puberty-blocking drugs, and it enjoined it statewide as to everyone. So let's see what the court has to say about that. So early in the litigation below, the district court issued a preliminary injunction. Ordinarily, injunctions like these may go no further than necessary to provide interim relief to the parties. In this case, however, the district court went much further, prohibiting a state from enforcing any aspect of its duly enacted law against anyone. Today, the court stays the district court's injunction to the extent that it applies to non-parties, which is to say, to the extent it provides universal relief. That is a welcome development. Now keep in mind, Justice Gorsuch is expressing his opinion here that this is a welcome development. As we'll see in a moment, that is not necessarily an opinion shared by others. To appreciate the significance of the court's ruling, some background helps. In 2023, Idaho adopted the Vulnerable Child Protection Act. The law sought to regulate a number of practices upon a child for the purposes of attempting to alter the child's sex. Those practices range from surgeries that sterilize or mutilate a child's genitalia to the supply of puberty-blocking medication. Idaho claimed that its law aimed to protect children from treatments that can cause lasting harm and irreversible damage. The law's provisions were scheduled to take effect in January of 2024. Before that could happen, two children and their parents sued Idaho's Attorney General and a local prosecutor in federal district court. The children and their parents alleged that without access to puberty blockers and estrogen, the two minor plaintiffs would likely suffer serious mental health problems. Shortly after filing the suit, the plaintiffs asked the district court to issue a preliminary injunction. The district court agreed to do so, but instead of enjoining state officials from enforcing the law with respect to the plaintiffs and drug treatments they sought, the district court issued an universal injunction. The court prohibited the defendants from enforcing any provision of the law, and that meant Idaho could not enforce its prohibition against surgeries to remove or alter children's genitals, even though no party before the court had sought access to those surgeries or demonstrated that Idaho's prohibition of them offended federal law. Now, why is that important? Because clearly, these two parents who sought access to puberty blockers, they did not have standing to challenge the action as it pertained to surgeries and that sort of thing. And that's because you have to have the threat of real injury, in that case not being able to get a surgery, in order to contest whether or not the statute is constitutional. And the people who sought the injunction here could not show that, so they lacked standing. But in spite of their lack of standing, the court went on ahead and issued the injunction, which Justice Gorsuch is now telling us, shouldn't have done that. And the court goes on to say that basically the injunction promised to suspend Idaho's law indefinitely too, as this litigation, like many today, may take years to reach final judgment. So one of the reasons the court is trying to exercise some restraint here in terms of the scope of the remedy, without deciding whether or not this is constitutional, because it doesn't have enough data. It doesn't have enough briefing to establish whether or not it's unconstitutional. The reason that it is taking this route is because, essentially, this blocks the entirety of the law, and it could take 3, 4, 5 years to get to the point where you have a judgment in this case. So Idaho sought review, and the Ninth Circuit refused to stay the injunction, and so they took it up to the United States Supreme Court. And it says, before us, the state does not challenge the preliminary injunction to the extent that it ensures the two minor plaintiffs in this case continued access to their drug treatments. That aspect of the district court's order will remain in place pending appeal. The state asks us to stay the preliminary injunction only to the extent that it bars Idaho from enforcing any aspect of its law against any person anywhere in the state. Now, there is a very good reason why the state of Idaho did not challenge the aspects of the injunction as it pertained to the named plaintiffs. One of the things that sometimes happens when you start someone on a course of hormone therapy and you have to withdraw that hormone therapy is that it can be very detrimental to the person from a mental health point of view. The legislature did not really think too carefully about what would happen if somebody was caught in the middle, in between things. And I think that the state took a reasonable position here and said, look, we're not going to contest this as it pertains to the people who are already on these blockers, but with respect to anybody else, we're not wanting anybody else to get put on them, and we want to be able to enforce our ban against the surgeries. So that's why they did not challenge this. It is essentially a concession to, okay, they're already on these. There's good medical reasons for them to not be withdrawn willy-nilly. And so that's why the state of Idaho took that position. And then it says, stay motions and other requests for interlocutory relief are nothing new or remarkable. Every court can grant them. Judges at all levels in the federal judiciary resolve these motions on a day-to-day basis. This court, like every other court, is guided by the same sound principles. We ask, 1, whether the stay applicant has made a strong showing that it is likely to succeed on the merits, whether it will suffer irreparable injury without a stay, whether the stay will substantially injure other parties interested in the proceeding, and 4, where the public interest lies. And curiously enough, the same 4 factors are the factors that have to be evaluated before you grant a preliminary injunction. So the district court, when it imposed this injunction, found that they were likely to succeed on the merits. That's why they're applying these standards. They're applying the same injunctions to stay an injunction that they would apply to grant an injunction. The court's discretion to enter a stay is not left up to its inclination, but rather to its judgment. Applying that traditional stay test here yields a ready answer. Start with the first question, whether Idaho has shown it's likely to succeed on the merits. The court has long held that a federal court's authority to fashion equitable relief is ordinarily constrained by the rules of equity known at the time of the separation of this country from Great Britain. Under those rules, the court has said a federal court may not issue an equitable remedy more burdensome to the defendant than necessary to redress the plaintiff's injuries. A remedy must be limited to the inadequacy that produced the injury in fact that the plaintiff has established. The district court's universal injunction defied these foundational principles. It did not just vindicate the plaintiff's access to drug treatments they sought, it purported to bar the enforcement of any provision of the law against anyone. By its own omission, the plaintiffs had failed to engage with other provisions of the Idaho law that don't presently affect them. In choosing such an extraordinary remedy, the district court clearly strayed from equity's traditional bounds. Now again, why is this important? Because the rules regarding equitable relief are well understood in the federal courts. A court cannot grant relief that is broader than that asked for or that which is necessary to redress the injury. So in this case, the injury was not being able to get puberty blockers. So the district court had the ability to address that injury for that plaintiff, which it did. Now, was that improvident? Maybe, maybe not. But whatever the answer is to whether it was improvident or not, that part of the district court's injunction will remain in effect during the pendency of the case. What will not remain in effect is the sweeping issue of surgeries and other sorts of things. Now, does that mean that somebody who wants access to a surgery couldn't file a second suit in the same court and get the same injunction as to that particular issue? Yes, they certainly could. If they could come up with at least 19 to 20 people who have the same issue with regard to access to surgical procedures, they could seek class certification. They could file a class action request for injunctive relief, and the court would then be able to issue the injunction as to members of that class, and assuming that the class was appropriately defined and that there was evidence to suggest that the injunction should issue, then again, that could happen. So while later in the dissent, Justice Jackson sort of horribilizes about all of this, the fact is that additional relief is available if people seek it, but you can't just throw out the baby with the bathwater, which is what the district court did in this case. The court then goes on and says the remaining stay factors, relative harms to the parties and the public interest, point to the same conclusion. Members of this court have long held that any time a state is enjoined by a court from effectuating statutes if enacted by their representatives, it suffers a form of irreparable injury. Likewise, this court has held that there is always a public interest in prompt execution of the law, absent a showing of its unconstitutionality. Both factors favor Idaho in this case. So the district court's order promised to run for the life of the lawsuit, thus preventing Idaho from executing any aspect of the law for years. Meanwhile, the plaintiffs face no harm from the partial stay the state requests. The dissent disputes none of this. It does not question that Idaho is entitled to relief under this court's traditional stay test. Instead, it laments the number of requests for interim relief that this court has recently faced in high-profile cases. It proposes adding to our traditional stay test new factors alien to our precedents in historical equitable practice. First, it suggests we should refuse to intervene when both a district court and a court of appeals have refused a party's request for interim relief. And they say, look, this is upside down. That's not how precedent works. The lower courts don't get to bind the Supreme Court. The Supreme Court gets to bind the lower courts. They also don't show how the rule it proposes would allow us to discharge faithfully our own obligation to assess fairly and independently the cases that come before us. Over the last 12 months, the court has repeatedly granted interim relief to the federal government in the face of contrary court rulings. So this has been an ongoing problem. Tucked away in a footnote, the dissent adds that it doesn't mean to suggest that the burden of overcoming adverse lower court decisions can never be carried. But if that's true, when does the dissent believe we should intervene and when not? So much for the added clarity, the restraint it hopes to bring to the law. In other words, the dissent misses the point here. Second, the dissent suggests that before granting relief, we should ask whether a case is cert-worthy, meaning whether if it came up on appeal or on an application for a writ of certiorari, whether the court would grant that relief. And here, the majority has decided that the case is worthy of the court's attention. This case poses a question about the propriety of universal injunctive relief, a question of great significance that has been in need of the court's attention for some time. Third, the dissent suggests the court should exercise caution and restraint, but if caution and restraint are our watchwords, why would a party's request for narrower rather than broader relief counsel against our intervention? Because that's what Justice Jackson said. Look, they're not requesting, that you throw this out as it pertains to the plaintiffs who are seeking relief, but that's the whole point, and that's the point of questioning the scope of the relief here. Do we really want to incentivize parties to seek more sweeping relief in order to enhance their chances of success in this court? And how does it serve caution and restraint for this court to allow lower courts to transgress foundational remedial principles more readily than foundational liability principles? In essence, while they pick apart the dissent basically says we should exercise some restraint here. Now, the parties who are suggesting that we exercise restraint are Kagan, Jackson, and Sotomayor, the three liberal justices on the court. And then the court goes on to say, as best I can tell, universal injunctions are a relatively new phenomenon. There was one during the Roosevelt tenure, 19 universal injunctions in President Barack Obama's administration, and during the Trump administration, there were 55 universal injunctions in the first 3 years. And in the past 12 months, if that's any indication, it seems the trend has continued apace during the administration of President Joseph R. Biden. rising number of universal injunctions virtually guarantees a rising number of high-profile cases will find their way to the court. Now again, why is that important? Because in many cases, some of these could probably be addressed better at the circuit court level, but also they're particularly in areas that are new. For example, artificial intelligence and things like that. Those are issues that are weighty and that are technical, and that briefing is necessary to position the court to understand the issues. And when it comes up in the emergency docket, you have a very limited amount of information that the court is working off of. So again, that's not a good thing. So if you limit the injunctive relief only to the applicants before the court, which has always been the way things have been done in pretty much every other situation of this nature, then you more effectively manage the resources of the Supreme Court. Supreme Court has 9 justices, and it has a number of clerks, 4 clerks for each judge, but at the end of the day, they only have so much time in a 24-hour day to work on these cases, and if the Supreme Court gets backed up, then a lot of times people are denied a remedy, or they are granted a remedy that they shouldn't be granted for some period of time. The court goes on to note that in so many other recent cases, the district court's universal injunction effectively transformed a limited dispute between a small number of parties focused on one feature of a law into a far more consequential referendum on the law's every provision as applied to anyone. And that's essentially what they're trying to correct. Now, if we go on down here, Justice Kavanaugh and Justice Barrett concur. They believe that there needs to be some addressing of this emergency application issue. Now, Justice Jackson writes for Sotomayor and Kagan, and when a party asks this court to sidestep the ordinary judicial process and intervene at an atypical juncture, our default should be restraint. Well, that's Judge Sotomayor, and that's in a dissent from a grant of stay. It has no precedential value here. They're just throwing it in there because they think it supports the case. We do not address every high-profile case percolating in lower courts, and there are usually many good reasons not to. And I agree completely with that. She goes on to say, as explained in Part 1 below, the state of Idaho's emergency applications asks us to override the decisions of 2 lower courts based on an issue not clearly implicated and under circumstances where the state does not contest that its law should remain enjoined as likely unconstitutional, at least as applied to the plaintiffs. And she sweeps a little too broadly there because the state said, look, we are opposing the remedy here. We're more than happy to litigate this issue in the district court. We oppose the remedy as it is way too overbroad, but we are not admitting that this is unconstitutional because clearly they don't think it is. Otherwise, they wouldn't be in front of the Supreme Court. It'd be pretty dumb to come to the Supreme Court and say, hey, we agree that this is unconstitutional, but we want you to let us enforce it anyway. So this is not a particularly strong argument that Judge Jackson makes here. She notes that the district court and the Ninth Circuit denied requests for stays and essentially argues through the course of this that the state has not come close to carrying its heavy burden in this case. No party disputes that assuming all the other factors were met, Idaho needs to show a reasonable probability this court will grant certiorari in order to obtain an emergency stay. Idaho maintains this case is cert-worthy because it raises the question of whether a district court can issue an injunction that grants relief directed to all potentially impacted non-parties, a so-called universal injunction. The only problem, that's not what the district court did here. Well, actually, it is what the district court did here. Otherwise, Judge Gorsuch and the rest of the court would not be intervening here. She's picking nits. She says that far from attempting to grant relief to parties not before it, the district court expressly stated that in the absence of class certification, injunctive reliefs generally should be limited to the named plaintiffs. Okay, that's what it said, but that's not what it did. Any error by the district court as to the necessity of preliminary relief it has chosen raises at best a fact-bound question, not a cert-worthy issue. Well, again, that's picking nits because overall, if you are not allowing the state to enforce its law for years and it is constitutional, then you really are injuring the people in the state of Idaho for years on end. So the court has made the right decision here. Justice Jackson just doesn't like it. She's very passionate about this. Her opinion is well written, and she raises issues that I think are important. And in fact, Judge Gorsuch says she's got a point. We do get way too many of these emergency applications. The court will at some point have to take this up. Now, what will happen going forward is the parties will litigate this case in the district court in Idaho. Whatever the district court determines to be the proper remedy will eventually go up to the Ninth Circuit Court of Appeals. Now, the Ninth Circuit Court of Appeals is very liberal. It has predominantly liberal justices because those justices come from California, Oregon, and Washington State, among others. And as a result, they do tend to be fairly liberal. At the point where the judge in the district court issues an injunction that is statewide and holds the law unconstitutional, the Ninth Circuit can be expected to certainly uphold that. And then the state of Idaho will seek certiorari from the Supreme Court. And the Supreme Court has pretty much already determined that it's going to issue a positive review on this particular case because it's high profile, it's newsworthy, it deals with an important issue of protecting minors, and irrespective of whatever else you may believe about transgendered individuals, first of all, I believe they should be treated with respect. I believe that for the most part, you should always honor their choice of pronouns. You know, when someone has an issue that affects their mental health, you should certainly try to take every step possible to try not to make that mental health problem worse. So it's just common sense and kindness to address them in the manner that they choose to be addressed by. That doesn't mean you have to believe as they believe. It just means you have to be a kind and decent person, and that's not too hard to do. At the end of the day, whether or not you're going to allow 8-year-olds and 10-year-olds to make decisions about whether they have surgery to have their body parts removed is fairly weighty, and the state certainly has an interest in that. And so I don't know how the Supreme Court is necessarily going to deal with this issue, but this will be one of those cases that we will follow on this channel, assuming that I don't leave this earth before the court gets to the case. Now, again, this case is going to take probably 3 to 4 years to get to the Supreme Court, so it's not going to be something we're going to find out about tomorrow, but it is an important issue. So that's what I have for you here today. It's a very controversial issue. I would be happy to have you weigh in on what you think. I am not going to offer an opinion on whether or not I think the law is constitutional because I don't have enough information to do that. I think that that's why we entrust the judiciary with their role to do this. And I think that the judiciary includes all of the judiciary all the way up to the Supreme Court. So we'll let them decide it. But I'd be interested in hearing your views on this. It is a very interesting and highly topical question that I think we need to talk about as a society so that we can form sort of a consensus of views as to how we think this problem ought to be addressed. On the one hand, many people believe that it should be addressed through some forms of therapy and helping people understand that gender dysphoria is a treatable condition. And then there are other people who believe that if a child wants to alter themselves, that they ought to be able to do that. I think people who have a libertarian bent would be very much in favor of allowing maximum freedom for people to do things like this. I think other people are much more likely to suggest that maybe the time to do this is after someone reaches 18. You know, if they have been on puberty blockers, or even if they haven't, if they have consistently viewed themselves in that manner all the way up through the age of 18, and they seek to have surgery, then I think that certainly is something that they should be able to do. It wouldn't be something I would do, but I don't suffer from gender dysphoria. I suffer from from other mental health issues, mostly just being a lawyer, I think. Anyway, the long and short of it is, it would be interesting to hear your views on this, and I would welcome you doing that. And perhaps we'll take some of those views and do a review of the comments section on this particular topic. I think that would be most interesting. If you have any comments, drop them in the comments down below. And of course, if you want, you can email me. If you email me and I like your comment, or I think your comment is worthy of review under on a video, I will, of course, mask your email address and your name so that you are not identified. I think that's only, again, common courtesy. But I will be happy to do that, so you can choose either route to get your comments to me. If you have the opportunity today, do something kind for someone. If you see someone that you think maybe is a man and asks you to refer to him as a woman, please be kind. Again, you don't have to agree with them. You just have to be kind. That's not asking too much. And then, after you're done, come on back down here tomorrow and catch me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.